Hi learners, welcome to the SOEM program. Today we are going to learn about intellectual property rights. Some basic information about intellectual property rights. What are the different... Hi learners, welcome back. Today we are going to learn about intellectual property rights. Today's agenda include categories of intellectual property, World Intellectual Property Organization WIPO, and major intellectual property treaties. Okay, so let us see what is intellectual property. Intellectual property means it is a creations of. Now let us see what is intellectual property. According to the World Intellectual Property Organization WIPO, intellectual property defines, quote, creations of the mind such as inventions, literary and artistic works, designs and symbols, names and images used in commerce, unquote. So that means intellectual property means it may be any inventions, literary and artistic works, or any sort of designs or symbols using as a trademarks, or a particular name or an image which is being used for the commercial purposes. All this include in the intellectual property. And what is intellectual property rights? Intellectual property rights is a set of legal protections granted to intellectual property creators and owners, including innovations, artistic work, literary creations, symbols, and designs. So, these intellectual property rights, in short known as IPR, fosters innovation, encourages investment in research and development. Repeat. The intellectual property rights, in short we known as IPR, fosters innovation, encourages investment in research and development, and rewards creative efforts by granting exclusive right to inventors, creators, and the business. IPR plays a vital role in facilitating economic growth, promoting competition, and ensuring that the innovators can benefit from their contributions. According to World Trade Organization, WTO, intellectual property rights are the rights given to creators over the creations of their minds by a government. The World Trade Organization, WTO, define intellectual property rights are the rights given to creators over the creations of their minds by a government authority. They usually give the creator an exclusive right over the use of his or her creation for a certain period of time. And there are different categories of intellectual property. The categories includes. Now let us check what are the different categories of intellectual property. The categories of intellectual properties are patents, trademarks, copyright, trade secrets, industrial design, and geographical indication. What is a patent? A patent is a government-granted exclusive right awarded to an inventor for a period of 20 years. It provides the inventor with the authority to prevent others from. The patent provides the inventor with the authority to prevent others from making or using, selling, importing, or offering the patented invention for sale during the term of the patent. After the 20-year period expires, the patent enters the public domain and allowing anyone to use the invention without the inventor's permission. An invention may include any new article, composition of matter, machine, process, or any novel improvement upon this. For example, the patent, we can say the Thomas Edison filed a patent for his invention of light bulb in the year 1879. And Google PageRank. Google PageRank is another example of a patent. Larry Page developed this patent in the year 1998 to calculate the importance of a web page based on number and quality of links at Google PageRank. And the new drug to treat cancer or display system for mobile phones, etc., are the examples of patents. Now let us see what is trademark. Trademarks protects. Now let us see what is trademarks. Trademarks protect symbols, names, or logos that distinguish goods or services in the marketplace. Registered trademarks prevent others from using similar marks that could cause confusion. Trademarks encompass a broad range of distinctive identifiers that serve to differentiate the goods or service of one entity. Trademarks encompass a broad range of distinctive identifiers that serve to differentiate the goods or services of any one entity from those of others. Say, for example, so the following elements may be protected under the trademark law: words or names. This category includes brand names, product name, or service names that are unique and serve to identify the source of good or services. The following elements may be protected under the trademark law: words or names, for example, brand names, product name, or service names that are unique and serve to identify the source of goods or services. The examples like Google, Reebok, and Nike. Okay, each representing the respective companies and their product. You find in the figure. And logos and symbols, for example, the graphic designs. Another type of trademark you'll find as well in the form of logos and symbols. Graphic designs, like another type of trademark you'll find in the form of logos and symbols, like graphic designs, logos or symbols that are associated with a particular brand, also under the trademark protection. For instance, the Nike swoosh and the McDonald's golden arcs are symbols that serve as a distinctive identifiers of these brands. And slogans like catchphrases or taglines that convey the brand's identity or messaging are another form of trademark. Notable examples include "Just Do It" of Nike and "I Am Loving It" of McDonald's, both of which are closely linked to the respective brands' marketing and consumer perceptions. And another type of IPR is copyrights. Copyright protects original creations in various fields, including literature, drama, music, art, and digital content such as software. It grants creators exclusive right to copy, distribute, perform, display, and license their works. In India, copyright protection lasts for the lifetime of the author plus an additional 60 years. This legal framework promotes creativity by ensuring creators can financially benefit from this work. This legal framework promotes creativity by ensuring creators they can financially benefit from their works. Unauthorized use of copyrighted materials considers infringement, and those found in violation may face legal consequences. And another IPR is trade secrets. Trade secrets refers Another IPR is trade secret. Trade secrets refer to confidential business information that gives a company a competitive edge, including things like manufacturing process, formulas, business strategies, and customer list. These secrets are protected as long as the information stays confidential and continue to provide a business advantage. This form of protection encourages innovation while allowing companies to retain their competitive position without revealing sensitive information. Unlike other types of intellectual property, trade secrets do not require formal registration. Instead, their protection relies on other types of intellectual property. Trade secrets do not require formal registration. Instead, their protection, unlike other types of intellectual property, trade secrets do not require formal registration. Instead, their protection, confidentiality, agreements, and unlike other types of intellectual property, trade secrets do not require formal registration. Instead, their protection relies on confidentiality, agreements, and security protocols. Google search algorithm, a critical component of its search engine, is a proprietary trade secret that is consistently refined to improve search relevance and the quality. Next is industrial design. Industrial design within intellectual property refers to the protection of a product's unique visual aspects such as its shape, configuration, color, or surface pattern. This type of intellectual property is essential for items whose appearance adds aesthetic or commercial value, making them appealing or recognizable to consumers. Unlike patents, industrial design protection safeguards only the aesthetic aspects of a product, not its technical or functional features. This protection is usually provided for a period of 10 years with the option to extend it for an additional 5 years. In India, industrial designs are protected under the Design Act of 2000 and regulated by the Office of the Controller General of Patents, Designs and Trademarks. In India, industrial designs are protected under the Design Act of 2000 and regulated by the Office of the Controller General of Patents, Designs and Trademarks. These are some examples of industrial design. You can see in the picture the table lamp. This is a classical piece of industrial design, was originally conceived in the year 1932 by George Carvadine. And another one you will find in the classic Vespa scooter design. So these are the examples of industrial design. Now let us see what is geographical indication. A unique subset of intellectual property rights known as geographical indications is intended to safeguard products that have a particular attributes, traits or a reputation that are inherently linked to their place of origin. Geographical indications protect the name of a product that can only be produced in a certain region because of special natural features, customs, or local knowledge. In contrast to the trademarks, which protect the brand identity and identity, geographical indications protects the name of a product that can only be produced in a certain region because of a special natural features, customs, or local knowledge. Geographical indication is different from geographical indication is differ from trademark because the trademark will protect brand identity, identify goods or services. For example, the Darjeeling tea from West Bengal, celebrated for its muscatel flavor, was the first Indian product to receive geographical. For example, Darjeeling tea from West Bengal, celebrated for its muscatel flavor, was the first Indian product to receive geographical indication protection. Next, we are going to discuss about the World Intellectual Property Organization, WIPO. The World Intellectual Property Organization, WIPO, is a United Nations specialized agency that contributes international treaties regarding intellectual property rights. WIPO was established in the year 1967 by the WIPO Convention, which states that WIPO's objective was to promote the protection of intellectual property throughout the world. WIPO headquartered in Geneva, Switzerland, and WIPO currently administers 24. WIPO headquarters in Geneva, Switzerland, and WIPO currently administers 24 treaties. In 1996, WIPO passed two treaties collectively known as the Internet Treaties in response to the demands of intellectual property holders worried about the infringement in cyberspace. Now let us see some major IP treaties. One is the Paris Convention. Learners, now let us discuss about some major intellectual property treaties. First one is the Paris Convention. It was adopted in the year 1883. It's known as a foundational international agreement addressing intellectual property rights. It has broad application to industrial property such as patents, trademarks, industrial design, utility models, service marks, trade names, geographical indications, and the repression of unfair competition. The Paris Convention, concluded in the year 1883, was revised in Brussels in 1900, at Washington in 1911, and The Hague in 1925, at London in 1934, at Lisbon in 1958, and at Stockholm in 1967, and was amended in the year 1979. Next important treaty we will find in the Berne Convention. In Berne Convention, founded in 1986 and amended in 1979, is a core international IP treaty. It protects authors' right over creative works globally across member nations. This convention built on three key principles. One is national treatment, automatic protection, and independence of protection, ensuring that literary, scientific, and artistic work of authors are protected across all contracting states, irrespective of forms or medium. The national treatment in this principle mandate that work originating from nationals of one contracting state must receive the same level of protection in other member of states as is granted to work. So now let us see what are the key principles of Berne Convention. The first one is national treatment. In this principle, mandates that works originating from nationals of one contracting state must receive the same level of protection in other member of states as it is granted to works by the nationals. Now let us see what are the major, the key principles of Berne Convention. The first one is national treatment. This principle mandates that works originating from nationals of one contracting state must receive the same level of protection in other member of states as it is granted to works by nationals of those states. This ensures uniform protection across borders. Another principle, automatic. The convention stipulates that protection is granted automatically upon the creation of a work without the need for any formal registration or administrative procedures, which is significant in safeguarding intellectual property. A third principle, independence of protection. And the third principle, independence of protection. Under this principle, the protection of work in one member state operates independently for the independence of protection. Under this principle, the protection of a work in one member state operates independently of whether it is protected in its country or of origin. However, if a contracting state provides a longer term of protection than the minimum required, and the work is no longer protected in its country of origin, the state may refuse further protection. Since its inception, the Berne Convention has undergone several revisions, including updates in Paris 1896, Berlin 1908, Rome 1928, Brussels in 1948, Stockholm in 1967, and Paris in 1971. Another treaty, trade related aspects, intellectual property rights, known as TRIPS. The TRIPS agreement, trade related aspects of intellectual property rights, was introduced in the year 1994 as a part of the agreements that established the World Trade Organization WTO. It came into force on January 1st, 1995. The agreement set comprehensive standards for the protection and enforcement of intellectual rights globally and binding of all WTO members. The trade-related aspects of intellectual property rights TRIPS agreement significantly influences how educational materials and resources are treated within the framework of intellectual property law. TRIPS sets minimum standards for copyright protection, covering works such as books, articles, software, and databases, which are very crucial for education. It grants authors exclusive right over the reproduction, distribution, and public performance of their work. However, TRIPS also allows exemptions for educational purposes. Article 10 permits the use of copyrighted works for teaching purposes, providing it aligns with fair practices and does not prejudice the legitimate interest of the right holder. Educational institutions may reproduce portions of works for classroom use under fair use or similar legal doctrines as long as this does not affect the commercial exploitation of the work. And TRIPS impacts the availability of scientific research and academic resources. Copyright rules apply to scientific publications and access many require permission or payment unless under the open access policies. However, developing countries can benefit from more flexible access to translations and reproductions for educational purposes, which helps mitigate the high cost of scholarly resources. So this TRIPS is very much relevant in educational settings where IP protection may limit access to scientific data and research tools. Now we are discussing on Digital Millennium Copyright Act (DMCA). It was enacted on October 12, 1998, is a significant US copyright law addressing issues related to digital content. It outlaws the creation, distribution, or provision of technology, devices, or services that are designed to bypass digital right management systems, which protect access to copyrighted materials. It also increases the penalties for copyright violation committed over the internet. By amending the Title 17 of the US Code, the Digital Millennium Copyright Act extends the scope of copyright protections while simultaneously limiting the liability of online service providers for copyright infringements committed by the users. There are some provisions of DMCA. It is a ban on bypassing digital protections. It prohibits the act of bypassing any technology or access control mechanism designed for protect legal content. Ban on distribution of circumvention tools. It prohibits the production and distribution of tools or technologies intended to bypass access control protections. And it also ban on anti-security tools. It prohibits trafficking in technology designed by and ban on anti-security tools. It prohibits trafficking in technology designed to bypass protection measures that prevent the unauthorized copying of copyrighted material. So, with these words, I would like to conclude this introduction about the intellectual property right. And I sincerely appreciate your attention today. And thank you very much. We'll meet with another topic in the next class. Till then, goodbye.